Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. My guest today is Yogi Patel from Lloyd Patel, LLP, an employment and business firm in New York City. Thanks for joining us, Yogi.
Thanks so much for having me, Steve. Really appreciate it.
So we're going to talk about employment law, and in this specific case, I9's and the E-Verify system, and potentially what the risks are, and also what happens with it when there's an audit. Can you explain those to us?
Yeah, absolutely. So in the United States, there is a process that an employer sort of has to engage in after they make an offer of employment. And generally speaking, I want to make this sort of clear, is that the issue of what an employee's immigration status is, it should not come up as part of the interview process, because that can be a basis under which an employer may be violating employment laws in the form of even asking that. So in other words, the inquiry as to whether or not an individual is able to work in the United States from the point of view of legally working as under the immigration laws does not come up until the offer of employment has been extended.
So first interview, screening, then offer, then you actually look into the immigration status issue.
That's correct, right? And that process is sort of known as the I-9 sort of verification process and requirement. And so every employer basically in the United States has to demonstrate that the individuals that they are employing are eligible to work in the United States, right? And that is a very specific sort of process and requirement. So what I mean by that is if all new employees prospective employees must complete an I-9 form. This form is a standard form that basically establishes which individuals are actually authorized to be employed in the United States. In other words, what type of forms and evidence and documentation do you need to provide to the employer to show that you can legally work in the United States? One issue to keep in mind there is that the I-9 laws are very clear about making sure that the employer is not prompting the employee into providing specific documentation. In other words,
wow,
the employer cannot prefer one document over another for the purposes of completing the form. They can't ask the employee to provide specific documents and point those out. In essence, what has to happen is the employer should provide the I-9 form, which actually spells out what documents are satisfactory, and leaves it up to the employee to decide which documents to present to the employer. And once those documents are presented, then the employer has really two ways of verifying whether or not the information is accurate. One of them is known as the E-Verify system. This is a electronic system that the US government has established, whereby you can enter these documents into the system, and there's an electronic report created as to whether or not those documents are authentic or not. And the other one is a visual inspection, whereby the employer can take a look at the documents that are provided and make an assessment as to whether or not those documents look accurate, complete, and whether they satisfy the I-9 form requirements. And if they do, then the employer is required to keep those records as part of the employment documents that they have to retain. One of the issues, Steve, that you mentioned was the audit process, and this comes into play, with respect to employers primarily. The idea here is that all employers must keep these records, meaning they must keep the records that the employees provided them during the hiring process as evidence of which documents they relied on.
So it's not just, hey, we've hired this Joe Public and now we can dispose of all those pre-hiring documents. We need to keep those.
That's correct. And there's significant penalties that are assessed against employers who do not retain these documents. And therefore, it's important to keep in mind, if you're an employee, that if you have a social security number, for example, that you get as a student, for example, that doesn't necessarily mean that social security card or number is valid for work authorization purposes. That
right.
generally
in fact, those cards often say only valid with current immigration status.
That's correct. So it's a two-part process. and therefore, providing a social security card is potentially one of the documents that's provided, but it's often going to be, if you're not a U.S. citizen, you'll need additional documentation on from the substantiate your immigration status or ability to work in the United States under that particular immigration status.
And unfortunately, to be honest, there are foreign nationals that are here in the United States that are no longer in status, that are presenting documents like social security numbers, which actually might have been valid at one time, or other documents to be able to work. And so the employer almost has to assume that they're not in status almost, right? Or they have to assume that let's go through this entire exhaustive system just to cover our own selves, I guess you could put it.
Yeah, absolutely. And not only that, I think the idea of re-verification is presumed in the law, that just because you go through this process once does not absolve the employer from actually especially if the status that the employee came in on was a temporary status, then the employer must mark down when that status expires and ask for the documentation that shows that they're back in compliance, or have something that carries through that expiration date, that keeps them in status and keeps them in compliance of the I-9 requirements as well.
You really have to stay on top of things if you're an employer then, because for example, we have cases where a spouse gets an employment authorization document through their other spouse who's sponsored for a work visa, but those have specific endpoints, and those EADs that they get correspond to those end dates. So the employer really has to stay on top of these things.
Absolutely, and we're seeing much more a lot of enforcement around these types of issues as of late. So this is not going to be, this is here to stay, and employers are cautioned to be really mindful of their obligations under the I-9 laws.
So I guess that's the last question I would ask, which I get the most often, is what are the potential penalties if someone is found to be not complying with this E-Verify system or with the I-9s? Yeah,
that's a great question. I mean, first of all, it depends on which department is, it's usually the Department of Justice in our experience that has a unit that looks into these issues. It comes up in a couple of different ways. It comes up either as a cross, if there's another government agency that has been investigating a separate matter that cross-refers this matter because they see some irregularities in hiring practices, we see this trigger come through. But depending on which agency it is and how many employees we're talking about, the willful nature of the violation, meaning, is it a technical violation? Is it a complete failure to observe any of these requirements? The fines can vary from $500 per employee per instance to as much as $5,000 per employee per instance.
Wow.
So these are very significant penalties that can be assessed. And, again, there's also, to the extent the employer is, willfully ignoring, all of these requirements and is purposely hiring individuals that don't have any type of documentation, there are also criminal penalties that could, that this matter could get referred.
Criminal penalties. So if it's systematic, if it's willful and systematic, essentially, that's when you run the highest risk.
Absolutely.
Okay, yeah. So for employers that are interested in knowing more, or realizing that the cost benefit of working with an attorney like you is just a no-brainer, because there's potential risk, especially for the kinds of industries that tend to hire undocumented foreign nationals. How do they get in touch with you? Obviously, this is a very profound and deep topic, but it's clear from what we've talked about that people really should practice prevention and be sure to document everything and to use this system that we have. How can you guide them? How do they get in touch with you to be able to do that?
Yeah, absolutely. Thank you, Steve. I mean, I think having, onboarding documents that are airtight, that reflect the current, status of the law, which is always changing, especially in this particular arena, is really the first step, and to document your way through it. And we work with business owners routinely to help make sure that they have all of these onboarding procedures and documents in place, and that they're systemized, and that in the event of any type of audit, they'd be able to defend themselves properly by virtue of the fact that they've documented themselves through this. They can reach me through our website at www.lloyd patel.com. There's a homepage. There's a page that leads to my bio, and there's a hyperlink that directly allows the clients to reach me by email with any questions they may have.
Okay, we'll put it on the screen also for everyone. Thanks so much for joining us, Yogi, and sharing some of your expertise and knowledge with us.
Thanks so much for having me, Steve. Really appreciate it.